Good morning. As has just been described, we're living in a changing world when it comes to employment tax, and particularly we're seeing a lot of attention over the status of workers and whether workers can avoid, or your engagement of workers can avoid PAYE and national insurance. I should say that we're going to have quite a lengthy question session at the end, so unless you've got a point of particular urgency or clarification, it would be best if we basically post the questions all at the end, and Nick and myself can deal with those together if that's acceptable to you. So what we are finding is there is an immense amount of interest by engagers and HMRC in the status of workers. And if you talk to senior officials in the Treasury, then they will tell you that in the area of employment tax, leaving aside tax avoidance schemes, which are being pursued vigorously, the next largest area of concern to them is that of status. And we've seen within the last couple of weeks in the press an announcement that last year the construction industry had to pay to the Exchequer £154 million because it had got the status of workers incorrect. And that amount had increased from, I think, the preceding year at around 130 million. So we can see, and that's just one sector, and we know of a number of sectors that are being particularly targeted by HMRC in regard to the wrong status of workers at this present time. Historically, a lot of engagers would just say to a worker, oh, how do you want to be engaged? And I get people tell me that they're taking on somebody and he just wants, or she just wants, to be treated as self-employed. And I get quite often asked the question, well, is that okay? Of course, it is not okay. It's not a matter of choice. It's a matter of fact as to whether a person is employed or self-employed, depending upon the terms and conditions of the particular contract that exists with that particular worker. Now, Nick, I know later, is going to go through some of the sort of lead cases that helps to determine the status of whether a person's employed or self-employed. So that will give an insight as to whether you can say, yes, I will accept you on a self-employed basis at this point in time. Another question that we get is, oh, I've seen that there's a self-employed friendly contract on the web. Can I just basically adopt that and take this person on, therefore as self-employed? And clearly, it's not a matter of, you can get the most nice-looking contract. In reality, it's what works in practice. And if you are involved with HMRC or the subject of challenge in this area by HMRC, it's not a case of what the contract says, it's what actually happens in reality, what is legally called substance over form. And I'm presently helping a client that's got 1,200 workers off payroll as self-employed. The revenue believe those workers are employees, and they've been knocking at the door of nearly 50 of those workers in the evenings. Around 9 p.m. seems to be a typical time, and asked entry and to go through a questionnaire with each of those individuals as to what their status is. And that's not unusual. I'm aware that as a firm we've got 4 similar clients who are having inquiries in different industries by a team that has been set up called the fraud team, which is not just interested in status, but they believe that if the worker is taken off payroll, that they may well be claiming benefits or other entitlements which are not actually due. So we're aware, one of my clients has got a couple of workers who are being prosecuted for false claims to benefits. as a result of them being taken off of payroll and this team's exercise. So it can be scary if you get it wrong. The historical position was, well, the revenue would just say, put them on the payroll from a future date, we might look for Class 1 national insurance. That's all gone out the window now, and effectively the revenue will look for retrospection in regard to any unpaid tax, which we'll come back to later, but particularly penalties. Even if there is no tax outstanding, the level of penalties that we're seeing in this area is quite significant. And there are proposed changes which is, Chris referred to the OTS, the Office of Tax Simplification. They have been working last summer on a paper, which you can find on their website. We were involved, I attended a number of meetings with different clients and trade bodies that I represent to make representations to the OTS. And the OTS report has made recommendations over how this should be made more black and white to take away any confusion going forward. And so I've said there is already, I've really explained where we are on that. What is proposed by the OTS report is that there is a statutory test as to whether a person is, for tax purposes, and I underline that because this will not impact, I think, on employment law, but for tax purposes, to take a person on as a self-employed person going forward, there will be a statutory test. And the government announced just prior to Christmas that they were adopting the recommendations of the OTS and would be publishing in the spring budget their proposals going forward. So we can expect by that statement that there will be the introduction of a statutory test in the near future. The question is whether that will apply from April 2016 or the revenue are minded to give a little bit more time and it might be 2017. The issue is that at this point in time there has been no publication as to what those statutory tests may be. When we were working on this about 10 years ago in regard to a specific challenge by HMRC on the construction industry, the tests that they were wanting to introduce at that stage, which may be adopted here, were really that the worker brought other people into or onto site. So effectively, it wasn't you just engaging Joe Bloggs, a plumber, electrician or plasterer or whatever, but Joe Bloggs and his workers. And if you could show that you were bringing in like a gang to work on site, then you could tick the statutory test. That you brought in significant heavy machinery and plant would be another factor. And each of these, you only had to pass one of the tests. And the third one suggested was that the subcontractor was VAT registered. Now, I don't know whether those are going to be the statutory tests that we can expect going forward. I know that meetings I've had in the past with Treasury, they rather like those tests. So it may well be that they are the tests that are adopted, but at this stage, we have to wait to see what is going to happen. But it is clearly an area that is going to significantly change the tax focus on the engagement of workers. But clearly, the revenue are not going to give up on the past. And what we're seeing clearly in this area is a lot of attacks. Whether it's part of an employer compliance review, they're picking up particular workers who are engaged off payroll, or they have an industry focus. So we know that the revenue fraud teams in the Northeast are looking at car valeting companies. They're looking at the construction industry, they're looking at haulage, and they are also interested in entertainers. That's what we understand is a particular focus at the moment. But clearly, as other areas become of risk, HMRC may extend into other areas of review. If you get it wrong now, since we've had the Demiborn case, as I alluded, it's not a case of saying just put the person on the payroll from the 5th of April 2016. Demiborn was a case regarding status that went through the courts. And Mr. Demiborn was a handyman working in a hotel who had been employed, left and came back as a self-employed handyman, and the revenue said, well, he's still employed. But the question was asked of the judge, because Mr. Demiborn had paid his Schedule D tax as a self-employed handyman, could that tax be offset against the PAYE now being sought by from the hotel by HMRC? And in the Demiborn case, that was considered, well, why are you asking that question? Because it's not a matter for the judge, and he got a little bit concerned at the question. So the government set up a working party called the Demiborn Committee, bizarrely, to discuss this. And the decision of that is that, yes, the Schedule D tax paid in this case by Mr. Demiborn could be offset against any PAYE. However, the bottom line issue, which causes concern when we come across this with HMRC, is when it gets to penalties, the penalties are calculated pre any Demiborn offset. So we've dealt with cases where there is a very small amount of outstanding PAYE because Joe Bloggs has been paying his Schedule D tax, and it's just a case that he's probably claimed expenses he would not get under PAYE that accounts for a difference. The problem is the penalties are charged on the maximum sum. So we've seen cases where we've got quite significant penalty loadings, which has come as quite a shock. And that is the point that people, when I talk to them about where the revenue are going on this, are not aware of this particular issue. So clearly, in light of this potential change with regard to status, and we'll have to wait the spring budget, it is important that you are aware that there may be change and that you can no longer, even if you could for the past, take workers on when you felt that they were self-employed for tax purposes. You may well find that the statutory tests would still bring them back into employment. And we're just going to have to wait to see where HMRC go on that and what guidance we get. But it is going to cause or create a lot of uncertainty in the marketplace over the next few months. And it's an easy target for HMRC as to revenue. The sums, as I said, £154 million from construction, and that's just one trade. And if you echo that across or put it across other trades, it is a significant amount of lost revenue to the Exchequer. Chris talked about the intermediary rules, and one of the things we have as a problem is when we say to someone that the intermediary rules have changed, the first question people say, well, what is an intermediary? Well, an intermediary, people then say, well, it's an agency. And so it's important to think that it's not just an agency, so it's not just a conventional employment agency, but it is anybody that provides labour to a third party. So you could have a situation where we as a firm of chartered accountants, you ask for us to provide you someone on secondment to come and help you in your finance department. We would then be in an intermediary situation. We've got companies where they second or send people from one company within a group to another company, and that could well be an intermediary. So it is actually quite a wide definition. And the changes to the intermediary rules actually occurred in April 2014. They were introduced very tight in a tight deadline by HMRC because of the loss of exchequer that was highlighted, and because of that they introduced it in 2 stages. At April 2014 the rules came in, which we'll go through in a minute, and then at April 2015 they introduced the requirement of the intermediary to provide returns on a quarterly basis to HMRC, and the fact that there are penalties for failures to operate the intermediary rules. But clearly the issue goes back to April 2014. And the rules with regard to intermediaries changed during the debate and discussion in 2014, and they cover anybody that basically is a worker that is being directed or controlled in the course of their duties. So effectively, if you've got somebody that goes to work for a company, say we second someone from an employment agency to work for us, if either the employment agency or we ourselves tell that worker what they're to do, when they're to do it, how they're to do it, if we're directing them, then these rules would apply. If effectively that worker is going away and deciding how they do their work and when they do their work, and there is no exercise of control, then it is outside the intermediary rules. And what I see coming along is people coming up with ideas to try and take contracts out of direction and control, and the Revenue have said that they're clearly going to be looking at this, and what the extension of the rules in April 14, when they decided to bring the rules in after consultation, was they decided that initially it was just if the agency or the provider of that worker exercised direction and control, and they've said no, it's if anybody in that arrangement. So that could be the provider of the worker or the end client is exercising direction and control. And that's particularly aimed at construction workers, because people who say someone going on a building site is not under direction or control because of health and safety. If there's anyone in the construction industry, they will be aware that they have to be controlled, and the Revenue firm views as to the fact that these people could not escape that particular tests. So the test that we've got from April 2014 is that if it's an overseas intermediary, then you, the end client. So if you've gone to an overseas intermediary or happen to have engaged a worker from an overseas intermediary, then you, the client, have to operate PAYE and national insurance on the payment you make to that intermediary. If you're a UK intermediary, then it is your responsibility, if there is direction or control, to operate PAYE and national insurance. If you believe that it's outside of PAYE and national insurance, then you have to prepare a quarterly return of the payments that you have made outside of that and provide it to HMRC. And there are penalties for failing to do that. For anyone who is providing workers in the oil and gas field, there are special rules, and I was not proposing to go through those today because I don't think we've got anyone in that area, but be mindful there are special rules in regard to that particular work. So really what we are coming across in our daily work with clients is sometimes workers being engaged by a company engaging a worker but not understanding where that worker has actually come from. And it transpires that they've gone to an agency who has actually engaged the worker through someone that might be outside the UK. And that would be a little bit of concern to the end client because he hasn't or she hasn't operated PAYE and national insurance on the payment. So it is useful if you are engaging workers to just ensure that they are being provided by a UK intermediary. if they're a UK intermediary, the responsibility sits with the UK company, the third party, to operate PAYE national insurance. And we're seeing a number of challenges in this particular area, particularly the revenue, because the list that goes in on a quarterly basis outside of payments outside PAYE and national insurance are being picked up, and we're seeing reviews by them. And that list includes, interestingly, not just workers engaged in their own right, but if they're engaged by their own personal service company and things of that nature. So it is giving the revenue quite a lot of information to actually look at things that are going on. So this is, interestingly, when we talk to clients who do use intermediaries, there is quite a lot of, shall we say, people unaware of these changing rules. And as these rules continue to be applied by HMRC, we're going to see them taking a more aggressive approach with regard to penalties. Umbrella companies, Chris referred to. What we've got, very briefly on this, is a change from April 2016 in regard to, shall we say, an exploitation of the rules of travel and subsistence that they have taken, which is going to be closed. So the worker engaged by that umbrella company cannot gain any or claim travel and subsistence over and above what they would have got if they had been effectively a worker of the end client. So it's to just put them on par. Clearly the government are very anti-umbrella companies, and their view is clearly that this will see out umbrella companies because the tax advantages will disappear. We wait to see if that's the case. If it's not, I think Mr. Osborne has a particular dislike that he will come up with additional measures because he wants umbrellas put to bed. So we'll just have to see where we go on that. But interestingly, over the last 2 weeks or so, umbrella companies have seemed to pick up these changes, and I've had requests for 2 meetings this week from 2 of them who've only just realised, well, we've got to do something from April. So it's very late in the day. Originally, this legislation was going to be introduced to April 2017. The Chancellor decided to close the loophole early, so it's happening from this April. And then finally, for my slot, personal service companies. What we've seen is a lot of people have seen the tightening up of the rules with regard to status, the tightening up in regard to intermediaries, and they've seen the answer to get round it to just say to the worker, well, just set yourself up as a limited company and we'll engage with you. Well, if life was just as simple as that, clearly the government, and particularly fuelled by the displeasure of the Public Accounts Committee, who feel that the revenue have been sitting on their hands, as it were, in regard to IR35, they have told the revenue in no uncertain terms, if you read the minutes of the Public Accounts Committee, that they've got to take action under IR35. And we're seeing a significant amount of attention in regard to IR35 at this particular point. So the areas that that are happening at the moment is we know that the revenue are looking out for personal service companies who are not accounting for IR35 when they do their tax computations. So this is effectively in workers who, because of the basis of their contract, would be considered worker, therefore under PAYE and national insurance, save that they've got a personal service company in the middle. And the rules, which came in 1999, effectively introduce legislation in that circumstance that you have to basically add back the expenses that you claim through your company so that you effectively take no tax advantage. And we're aware that there are particular issues in particular sectors. Media, the revenue have been quite public about certain BBC presenters, and we know that there are 2 leading cases that are going against well-known presenters who have been engaged by the BEEB on via personal service companies, but when they've done their tax computations have not accounted under IR35. I dealt or was asked to look at one in regard to not a BBC but another TV production of an individual, and that individual had for several years been a presenter on the TV, not accounted for IR35, and the amount that the revenue was seeking were in excess of £1 million. It is substantial, and they are the revenue have the list of presenters, particularly through the TV programmes. They've got an agreement with the TV programmes about IR35, and all sides seem to be on the same page as to when IR35 bites, and they are going after them. So that's one thing that's happening. The problem the revenue have is identifying when they get a set of accounts or a tax computation if it's a personal service company. And that's the issue, why the revenue, leaving aside the fact that they've not had resource, they have not been very good at challenging. And Chris referred to the recommendations that were in the consultative document. Consultation period is now closed, but the decision appears to be that if you are engaging workers via a personal service company in a long-standing arrangement that is over a 4-week period, say that in excess of 4 weeks, if the contract exceeds 4 weeks or above, PAYE and national insurance will be operated or should be operated by the end client. That's what seems to be the recommendation that is coming out and is to be adopted. The revenue suggested shortly after the autumn statement, I think it was, that they will be making an announcement early in 2016. And the stuff we've seen is suggesting that that may well be the announcement that we get. But there's obviously pressure on the revenue saying that's ridiculous, and we just have to see where it actually finishes. There are other issues. Clearly, if you are engaging workers via a personal service company, it is imperative that you check that it's a UK personal service company. We come across from time to time people engaging workers by an Isle of Man company or Jersey or Cayman Islands or something like that. Effectively, in that situation, under the existing tax rules, you should be operating PAYE national insurance on the payments that you make to that limited company because it's outside the UK jurisdiction. And we're seeing the revenue. In fact, I had a meeting in this room with the revenue about 18 months ago where they took action against a company because they hadn't picked up it was an overseas personal service company. The other issue is non-exec directors. Pain of a tax advisor's life in a way, where people say, oh, we can engage them via a personal service company. No, you can't. If they do continue to be engaged by a personal service company, then they are caught to IR35. But in strictness, the rules were made clear in legislation introduced in 2014 that PAYE and national insurance applies to a non-exec director. And that follows the public accounts interest in the use of non-exec directors off payroll within the public sector. So it is dangerous now just to assume that it's okay to use workers, and that's a common issue that we come across at the time of a PAYE audit that the revenue are picking up. So I'm sorry to be a prophet of doom and gloom, as it were, but I think these are issues that are changing, we're living actually in a very much a changing world in regard to the engagement of workers. And it's quite amazing that, yes, there's been press publicity, like on the construction industry, but the scale of it just does not seem to have been properly recognised across the employment sector. And so it is something that you just need to be aware of and prepare and ensure that your systems are robust to cope with this changing world. Thank you. I'm going to hand to Nick.
Excellent. Well, good morning, everybody. Managed to work the IT. So, following on from Alistair's talk, having been an employment lawyer for a number of years, it's quite clear that the whole area of employed, self-employed, is quite a complicated area. And there's quite a lot of ignorance. There are a lot of people out there who are so-called self-employed, but are in reality employees, and vice versa sometimes. And the Office of Tax Implications, as just referred to, have come up with a report, and they say, well, there's undoubtedly a problem, and it's a growing problem. And if you think about perhaps the last 30 years of changes in working patterns and things of that nature, it's hardly surprising. There's been a lot more flexible working, or desire to work flexibly. Companies, for example, want to flex their workforce. Sometimes in great demand, they want a greater number of workers. Other times they want to reduce them. And also individuals want flexibility, perhaps more women, working mothers, things like that, coming back to work. They want to work as flexibly as possible. And the difficulty is, if you get it wrong, you have all sorts of risks of employment claims. It's amazing, isn't it, how many times you see people who have been merrily self-employed for many years, suddenly their contract is terminated, and suddenly they become an employee, and they launch an employment tribunal claim. Because they say, well, actually, in reality, being an employee, I don't like the way you've treated me, so I'm now going to hit you with an employment claim. And it's likely that the company, in terminating that contract, won't have followed any employment procedure, because, of course, they won't have regarded them as an employee. So we don't need to follow that procedure. And, of course, if that person is deemed to be an employee, then they're likely to succeed in their unfair dismissal claim or whatever claim they're bringing. So I think also a lot of companies have been thinking, well, if we can have someone who's self-employed, we can avoid all that employment problems and increase in legislation, a lot of it coming from Europe, and we can get around that. Well, if you don't get it right, you can be on the end of claims that you otherwise thought you would never have. There's also the distinction between the cost of having someone as self-employed employed, tax, NI particularly, but also the burden of employing people, payroll, auto-enrolment now coming up, all sorts of other areas. So it's not surprising that people try and bend the rules to make it suit them. And the difficulty is, hopefully the wheel doesn't come off. So there is a lot of confusion in this area, and it is difficult. Sometimes it's even difficult for the likes of us to work out certain statuses and situations, but we obviously do our best. And I see a number of clients who have people who are supposedly self-employed, but really they're employees, just dressed up in self-employed clothes. A sort of contract that vaguely looks like a self-employed situation. And also amazing how many companies think, well, we'll save some money here, let's just terminate your employment contract, we'll just offer you a consultancy agreement, and you can carry on doing exactly the same job, but you can do it through your own company, and we'll save tax and NI, and it's better for you as well. Well, that goes on quite a lot too. And when you look at those contracts, it's amazing how badly drafted they are. Alistair referred to people getting things off the internet. Well, if you do that, you can run the risk of being a bit of a fool. But I'm amazed how many consultancy agreements I've seen where essentially they're bastardised employment contracts. And therefore, if you are going to argue one way or the other, then at least get the right contract in place. Obviously, I've mentioned potential employment claims, but also the risk of tax and NI liabilities. Alistair's mentioned the penalties. If you get it wrong and the revenue hit you, you may have to pay back all sorts of tax. You don't want someone looking over your books, perhaps going through the company's accounts, etc. How many other people have been like this, and the revenue be looking to try and claw money back. And even if the revenue determine somebody is self-employed, that's not the end of the case, because from an employment law perspective, things aren't always the same as the revenue themselves. If we look at the auto cleanse case, for example, they were car ballators, 20 of them. They were given a contract which said they didn't have to do the work if they didn't want to, and also they could substitute somebody else. Well, the court, Revenue said yes, they're self-employed. The court wasn't satisfied with that. They looked behind the scenes, they looked at the whole circumstances of the situation, and they deemed those individuals to be employees. The contract was a bit of a sham, so it didn't work. So what you've got really over the last 30, 40 years is a considerable increase in the number of one-man limited companies, part-time companies, people coming back to work, working flexibly. And in 2014, roughly, they worked out there was about 31 million employed or workers in the UK, of which about 5 million were self-employed, and quite a lot of that was part-time. So the question is, are they really employees, or are they actually genuinely self-employed? Then we've had the introduction of the title of worker, which has sort of blurred the scene somewhat. Really introduced probably from about the mid-90s, quite often emanating from European legislation, for example, the Working Time Directive, etc. And what does that mean? Well, as a definition of worker, they're either an employee, which is what you'd normally see. They're under a contract of employment, a contract of service or apprenticeship. Of course, you don't have to have it in writing, but it's better if it is. It could be just oral. And whether someone is an employee or a worker or self-employed is a question of fact and law when they look at the whole circumstances. The other side of a worker is this one. Any other contract, express or implied, where the individual undertakes to do or perform any work or services for another party to the contract whose status, by virtue of that contract, is not that of a client or customer of any profession carried on by that individual. So if they're genuinely self-employed and they have that arrangement works, they will not be a worker. But a lot of people fall into this category if they're casual workers, freelancers, things like this. 0 hours contracts, which is in the news recently, and the government have been looking at that. And one other example in a case is really a self-employed joiner basically ran his own company, and he provided his services really to one building company only, and he was deemed to be a worker, not self-employed. He wasn't an employee, but he was deemed to be a worker. And the Byrne brothers case looked at this, and they looked carefully at some of the criteria they look at to determine whether someone's a worker or not. And in particular, they were looking at whether the individual provides the services personally, or can they substitute their services to somebody else. And even if there is a limited right to provide a substitute, it may still mean they're a worker. And the court also looked at it, well, this definition of worker, it seems very wide, doesn't it? It could almost cover anyone. Well, actually, they thought that Parliament hadn't intended that consequence, and therefore there is this intermediary type status of worker. So either they're an employee, or they're a worker, or they're self-employed, and there's that bit in the middle. And this is why it's caused a bit more confusion for people. Now, employees have statutory rights, as you're aware: unfair dismissal, redundancy pay, maternity pay, all sorts of things that you can think of that employees have rights of. And workers are now beginning to be given more and more rights. For example, the right to paid holiday, right to the national minimum wage, public interest disclosure, whistleblowing as we call it, part-time workers regulations. So gradually through mission creep, they're getting more and more rights in this particular area. And that means that the whole issue of employment status, of determining what status somebody is, can become more complicated. HMRC have a formal checklist, which Alistair has referred to, and just because the HMRC determines someone to be self-employed does not mean they're not necessarily an employee, so you need to consider that sort of test. This statutory test they're thinking of introducing, will be interesting to see how that is introduced. If it's as Alistair described, only certain limited areas, then it may not have an impact on the case law under employment law. If, however, it's more widely introduced, in other words, it's saying to the courts, this is how you should determine someone to be an employee, then that could have considerable ramifications in the employment law field. So the moral of the story really is, get it right the first time. If you're engaging someone, think very carefully about what are the circumstances, how they're being engaged, what are the terms, things like that, and get it right first time if you can. And what I'm now going to do is really look at a whole series of criteria which the courts will look at based on the cases over a number of years to help you assess perhaps who you've got in your organisation, who you're engaging, as to whether they're an employee, whether they be a worker or otherwise. So the first one an important one, is mutual obligation. Often employers are under an obligation to provide employees with regular work, and the employees are obliged to turn up and do that work. A fairly standard type situation. If someone's free to go and come and go as they please, they're only paid when they work, things of that nature, they're not integrated, then they may not be an employee. And companies, self-employed arrangements, the individual really, or the company concerned, can decide whether or not they accept the engagement. It's up to them. It's not an obligation to accept it. And that's where we look at. So the whole area of, is there a mutual obligation? Second area, is there a degree of control? Alistair's already mentioned control, but is the employee under control of somebody? Do they report to someone? Do they have a title, job title? Are there rules and regulations which govern the way they provide their service? Whereas a self-employed individual often has the ability to determine when and how they work, and not normally under direct supervision. Of course, it's normally some light supervision or light indication, but it's not like the degree of control of the master and servant relationship of an employment situation. Personal service, do they provide their services personally, or can they provide a substitute? Do they provide a substitute? Employee, obviously, it's a named employee, their name is in the contract, it's them, that's the work they're providing. With a self-employed situation or a company, there's often the right to provide a substitute of parts of their workforce, things of that nature. Exclusivity. Employees normally only able to work for that organisation, can't work for others without consent. Whereas often in a self-employed situation, and this is particularly pertinent when I look at contractors, do they provide services to other organisations as well, or is it merely one organisation? It's often quite a good indication. And if they provide their services to others, then it's more likely to be in a self-employed situation. Of course, there may be limits to that. Of course, you can put in your consultancy agreements, for example, that they cannot work for a competitor, or if they're working on anything which would have an impact on the ultimate client to whom they're working, then you can make some restrictions in that regard. What about the nature and length of the engagement? Normally, most contracts are open-ended, obviously right to notice, unless it's a fixed-term contract for a particular period, whereas a self-employed situation is normally for a finite period, for a particular project, or something of that nature. Pay and benefits. How is the individual person paid? Obviously, it's quite clear with the employee they're paid through the PAYE payroll, salary, benefits, things of that nature, life insurance, PHI, health insurance, the usual type of things. Sometimes you even see those, believe it or not, in self-employed contracts. That isn't going to work if you're not careful. Normally a self-employed individual is paid on completion of a task, or there is a monthly fee depending on what services are being provided, and there shouldn't really be any benefits there, or the employment type clauses that you would normally see in an employment contract. Do they provide any facilities and equipment? Alistair's already mentioned this. Normally an employer provides all the equipment to the employee, not always, but most of the time, whereas a self-employed individual often provides their own equipment and tools in order to perform most of the services. And there are various other factors which they look at. Is the person integrated into the business? I've got a construction business, and two of the directors, believe it or not, are on self-employed contracts. And they've got title operations director, commercial director. And I've said to him, look, this isn't going to work. He said, well, I need these guys. That's the only way in which I can have them. I'll take the risk. If they're integrated into the business, quite clearly, got titles, all of the number of the other factors apply to that particular company, they are likely to be deemed to be employees. So that's a recipe waiting to happen. Who's responsible for the tax? Now, most consultancy agreements say that the individual is not an employee, they're responsible for their own tax national insurance and so forth, etc. Do they take any financial risk? Stringfellow's case is quite an amusing case. Ms. Queshy was a lap dancer in Stringfellow's. She was effectively, or contract or whatever it was brought to an end because they thought she was on drugs. She then claimed that she was an employee. I think Alistair was involved in this case, in a professional capacity, I have to say. But the question was she an employee or not? In reality, they said there wasn't a mutuality of obligation. If she came and worked at the club, she actually paid for the privilege of working at the club, and the way in which she got paid was because of the punters, as it were, or the attendees to the club used to pay her for her lap dancing. And it was deemed that she actually took the financial risk. There wasn't a mutuality of obligation, and interesting enough, she was not deemed to be an employee. So does the individual have some financial risk in the work they do? Have they invested in the business? Might be a factor. Are they part of the management or not? Do they profit from their own performance, or do they profit from the business as a whole? And then often you find people who are self-employed and they say, well, yes, we give them holiday pay, give them sick pay when they're sick. Well, why? Are they an employee or not? So a lot of these things they will look at in the contractual terms, but under employment law, they won't just look at the contract, they'll look at the whole circumstances to factor in order to determine whether someone's an employee. So, really, action, if you think about who you've got working in your business, or providing services to your business, or to your clients' businesses, you advise clients, what have they got? Have they got it right? Are there people there who perhaps on the borderline, it's all a bit grey, or we know they're taking a risk? Have a look at their circumstance, the whole package really of what they do, how they're paid, what control they have, and all those factors that I've already gone and indicated. Look at the contractual terms. Does the contract look like a bastardised employment contract? If you want to argue that someone's genuinely self-employed, then have the right contractual terms in place to give you the best possible argument. Don't just use a contract that somebody's given you or taken off the internet. Think about the risks to your business of it. Think about what the revenue is doing, and the way that they're knocking on doors and closing down on this is now the time perhaps to have a good review and try and minimise those risks for your business. And do you really need to take action in order to try and limit this risk and limit the problems that might arise as a result? I'm just going to finish off very quickly with a little bit of an update before we go on to questions on some of the latest things in employment law. Restricted covenants, because we're talking about contracts, etc. There's been a case recently where Mr. Sendall worked for a company. He'd been there about 14, 15 years. He resigned. About a year before he resigned, he was given a new contract of employment. He had never had in his contract before any post-termination restrictions, i.e. which limited his activities after he left. For example, non-solicitation of clients, non-dealing with clients, non-competition clauses, that type of thing. And he was given this new contract and signed it. He then went off and the company tried to impose those restrictions. And what the court essentially said was, well, when he was given that contract, there was no consideration or benefit that he was given at that time. It wasn't like he was given a pay rise, but it wasn't linked to the contract in question. So the moral of the story is, if you are imposing or giving new contracts or imposing new restrictions on employees, then there needs to be some benefit or consideration given at the same time, or it needs to be linked to something in order to give it a chance of being effective. Second one, 0 hours contracts. I've touched on this briefly. Some new legislation which came in this month, which basically says that if you have exclusivity clauses in a 0 hours contract saying that they can only provide their services to that company, that will be illegal, and that anyone who's dismissed as a result of that or suffer detriment as a result of refusing to sign that type of contract will be able to bring an employment claim in the employment tribunal. So that's a new piece of legislation. And then holiday pay is not that new, but it came in last year. The whole question as to what you should pay someone when they're on holiday has come into the forefront, largely because things like if people regularly work overtime, when they're on holiday they're not working overtime, therefore if they've just been paid their basic pay, they're not being paid what they should be in terms of holiday pay. So areas such as overtime, commission potentially, things of that nature, you may need to take into account. And with one particular client, they worked out that actually they've probably got a liability of £120,000 a year, which if they had to pay it all over to their employees, would obviously cause them a considerable amount of money. So there may be a number of other companies out there who are not really paying what they should be paying in terms of holiday pay, and there could be potential risks of claims in that direction. So that's finishing up on my bit, and now we're very open to questions from the floor, if we may.